for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we're going to hear this morning is Herlihy versus DBMP, and Mr. Rucktuschel, we'll hear from you first.
Thank you, Your Honors, and may it please the Court. Jonathan Rucktuschel on behalf of the appellants. In denying the appellant's motion for relief from the automatic stay, the bankruptcy court committed an error of law when it failed to properly apply the legal standards governing relief from the automatic stay for cause under 11 U.S.C. 362 D1. The court failed to apply the burden of proof under 11 U.S.C. 362 G and changed the rule of the Robbins case for evaluating cause for live stay from evaluating harm to the estate to harm to the proceeding as reflected on page 1 of the appellant's brief. Right, so the change is from estate to proceeding. The court also failed to consider the impact of the debtor's admitted lack of financial distress and the implications of that with respect to the good faith of the bankruptcy filing itself when making its ruling. The court further made numerous clearly erroneous purported findings of fact that were unsupported by record evidence or contrary to the record. Because no cognizable harm to the estate was established by the debtor, who admits it can pay all of its creditors in full, and because Congress squarely allocates the burden of proof on resisting a motion to lift stay on the debtor under 11 U.S.C. 362 G, stay relief was required under 11 U.S.C. 362 D's mandatory language. And we ask that the court reverse the bankruptcy court's order, and because the relevant facts are not in dispute, we ask that this court grant appellant's motion for limited relief from the automatic stay so that they can liquidate their claims before a jury and cement the value of their claim in this bankruptcy proceeding, only to return and await the conclusion of the bankruptcy proceeding. We've never asked and are not asking for the right to collect on that judgment, simply to liquidate the claim and know how much my clients are owed, to have their day in court. I'd like to briefly discuss the congressional purpose for the bankruptcy code in the factual setting of this case, because that purpose and the facts of this case color the way that this court can and must evaluate the question of cause under 362D. I'd then like to review the evidence before the bankruptcy court and the court's legal and factual errors deciding appellant's motion for relief from stay. And I'd like to conclude with a discussion of why it's critical that this court address the elephant in the room, right? Whether these non-distressed Texas two-step tort reform bankruptcies are a proper use of the bankruptcy court.
You say the bankrupt was not in distress?
Absolutely. It's not disputed. It's been found by the bankruptcy court. So,
well, when you look at the congressional statement as to when they enacted 524G, they were overtly imitating and mimicking Mansfield case and implemented it almost per se. And they said that the issue in that case was the stress created by the long manifestation of the disease that would linger over these corporations and hurt not only the claimants, but the company and the public. And they explained that in some detail, and they described that as the stress that they were addressing. And they made clear that the claimants would do well, fine, because of the trust fund that was created and which was guaranteed. So should we ignore that articulated purpose? I mean, it's not in the statute, but the statute was peculiarly addressing the asbestos situation where the asbestos develops over, or mesothelioma develops. You can help me out.
Mesothelioma.
Mesothelioma, thank you. That develops over sometimes 40 years, and so the tail of, or the long tail of claimants is the stress they were talking about, and they described how that affected corporations and the ongoing welfare of the claimants and the corporation. And so, I guess you want us to just, I guess, ignore that or no?
Absolutely not, Your Honor. And I think this is a great example of how the bankruptcy court had glossed by the whole picture. Because you're absolutely right that the description of why the conundrum that the bankruptcy court initially addressed in Johns Manville arose is because of the long latency of asbestos diseases. But the reason that it was necessary to enact a trust solution to the Johns Manville problem was because Johns Manville was financially distressed and there wasn't enough money to pay current and future claimants.
But
right?
the Congress made clear that the stress in this case is not defined the way you apparently define it. In other words, it's not insolvency. As you know, Chapter 11 requires insolvency only with respect to municipalities, and does not with respect to other entities that are in Title 11. The qualifications for Title 11 are set forth in the provisions, but and I'm not sure even in Mansville, at that point they were insolvent, but they didn't focus on that. They clearly focused, and they said this explicitly, the stress comes from the fact that this liability is going to stretch out for up to 40 years and both hinder procedurally and economically the corporation, and there was no hurt to the claimants because they were all being treated the same through the trust fund. And the trust fund, of course, here is going to be guaranteed by new certainty, right?
So that's true. You know, where Your Honor is not quite finishing the loop with respect to the legislative history is in the same legislative history. Congress makes clear that it's enacting 524G for companies that are facing, in its words, similarly overwhelming asbestos liabilities. Right?
That's right, in terms of numbers of potential claims.
No.
And that's what they talked about. They talked about the numbers of claimants. And in this case, we have what, evidence, 60,000?
So
this one actually may be more than some of the Mansville claims.
So in terms of number of claims that are pending in the court system, that's absolutely true. In terms of number of claims that are actively being litigated, the record evidence, which is established at Joint Appendix 96 in the debtor's own filings with the bankruptcy court, show that the debtor had a predictable stream of about 1,400 cases a year that were being filed against it. 60% were being dismissed without payment by the court, 20% being paid a nuisance amount of less than $50,000.
But they don't even know all of them. I mean, that's the problem. That's the whole purpose of 524G, is they don't know them all. There are cases potentially down the road. There may be some pending. It's not a question of what the current status is of the number. It's a question of the potential liability that stresses both the claimants, because there may not be money for them, and the company, where there may not be money for it. And so Congress addressed that stress. They defined that explicitly in their...
So I understand your Honor's point, right? I don't believe that that is a complete reading of the legislative history regarding 524G.
I'll go back and read it again.
Because what Congress says explicitly is what we're trying to do is make sure everybody understands that what was done by the bankruptcy court in Johns Manville is okay. We're trying to enshrine that to remove any uncertainty from any future companies facing with overwhelming asbestos liabilities. Not overwhelming number of claims, overwhelming liabilities.
Well, I
That's
think
the phrase that Congress used.
They use that, but they also, they defined that by the number of claimants. They kept referring to the numbers. I think there was between, what, 30,000 and 100,000 or something they predicted.
It was much lower. Right. I think there were 12,000 claims
well,
pending.
They had a big range. I can't recite the statutory history, but my point is the statutory history focuses on the stress created by the indeterminacy of the claims at this point.
And Your Honor, I simply disagree with that in terms of what the overall reading of the statutory history is, because the statutory history cannot be cut apart from what it's referring to when it says we're trying to enshrine what happened in Johns Manville.
Well, let me ask you this. If you're right, let me flow with you for a minute. If you're right, I guess then we can't use, in a circumstance we have like here, we can't use 524G. You want to lift the stay. The claimants will go ahead, so the benefits of 524G will not be realized. Or you want us to go further and even find unconstitutional or violating, I don't know, what remedy would you want? You want to lift the stay, but...
The request, all we're asking for here, Your Honor, is the request to lift the stay so my client
so
can
what would
liquidate their
happen?
claim.
So the claimants would then go into courts around the country and pursue their claims over the period of years, and they'd keep filing them, right? That's what would happen.
Well, no, we're only seeking
And
relief.
they talked about 60,000.
You're seeking relief for two,
We're only seeking relief from stay
For two
for
estates.
my two clients, the Hurleys and the Bergroods. And there's no evidence that anyone else is going to seek to have the stay lifted. Because there's a significant risk in this, because my clients would go and liquidate their claim. They're going to come back to the bankruptcy court and await its conclusion, which the debtor is still going to try and have a 524G plan.
But that would frustrate Congress's explicit purpose of making the claims treated equally.
Well-
To treat your clients in one way and treat the other claimants in a different way.
So that again, I believe, Your Honor, is passing the step of Manville being a situation where there wasn't enough money to pay current and future claimants. And that was the whole point, right? The whole point of 524G, codifying what happened in Manville, is we're going to set some money aside for future claimants because there's not enough money to pay present and future claimants, right? There was a limited fund, right? And in the absence of a limited fund, the rights of future claimants cannot be impaired with respect to their jury trial rights under the Seventh Amendment because they're not before the court. This is the conclusion of Amchem and Ortiz, right? So with respect to what we're asking for, we want the right to liquidate our claim, and it sets the value for my client. Now, the implications of that, if a plan is ever proposed and 6 years in, it's not, and a plan is ever sent out for votes and 6 years in, nothing has happened. And if a plan is ever approved, well, then we'll fight on whether it can be confirmed and what the implications are of my client liquidating their claim flow from the statute.
Can I just ask you a question again about the remedy you're asking for? Because it does seem like there's kind of a mismatch, right? Your basic position is this case does not belong in bankruptcy. But if you prevail, the case stays in bankruptcy, and it's just that if the bankruptcy judge is right, like all the benefits of that disappear because now you've got 60,000 claims working their way through the tort system. I understand you're only asking for 2 people, but I'm, for purposes of this question, assuming the district court's prediction was correct. Isn't that an odd outcome? Like, you think this case shouldn't be in bankruptcy, but at the end of the day, the case will be in bankruptcy, but without any of the benefits of bankruptcy.
I think the best answer to that is phrased in the context of my 2 clients, right? Mr. Hurley, he is a living mesothelioma victim, right? He is literally living on borrowed time. He wants his day in court. That is his right. And Congress has carved personal injury claimants out of the bankruptcy code. They're the only types of creditors that are absolutely entitled under 28 U.S.C. 157 to have a jury trial to quantify their claim, right? That is an absolute right guaranteed by Congress. In California, where Mr. Hurley lives, he has a state law right to an expedited trial. He's a living mesothelioma victim. Given his age and his condition, he can get a trial in 90 days, right? So if the stay is lifted, the Hurleys, and I spoke with Mrs. Hurley yesterday, she's a court reporter, and she knows this process. She wants her day in court, right? They can ask, as soon as the stay is lifted, they can ask the California court for a trial date. They'll get one 90 days out. They can go. They can liquidate their claim. Maybe they win. Maybe they lose. Maybe they settle with certainty, right? In A.H. Robbins, in footnote 17, the court notes that under 157B, when a case is referred out for trial so that it can be liquidated before a jury, that doesn't mean it has to be tried to verdict, right? The proposition that if you lifted the stay for everybody, you'd have 60,000 cases going to
You're
verdict.
making a case for whether Congress should have passed 524G.
Absolutely not.
But if 524G is there and is to be enforced, you have to argue why your clients aren't under 524G.
So, Your Honor, I don't believe that's correct, and I think all you need to do is look at 524G7, right? Which specifically says nothing in the enactment of 524G changes the system of referring cases to the bankruptcy court through the district court under 28 U.S.C. 157, which is the section of the code that preserves my client's right to liquidate their claim in front of a jury, right? And so Congress, in enacting 524G, says we're not changing this system. We're not changing the rights of personal injury claimants to liquidate their claim. Again, personal injury claimants are the only type of creditor in bankruptcy that is allowed an absolute right to liquidate their claim in front of a jury.
But
any argument,
there's a subclass of those persons who are persons suffering from asbestosis that Congress addressed. In other words, they made the asbestosis claimants a special class and treated them in a special manner.
no, they created, so Your Honor, Congress created a remedy. 524G is a remedy for...
Whole process.
It is, for companies that are properly in bankruptcy. And the purpose of Chapter 11 is to allow for the rehabilitation of financially distressed companies. If we look at...
Yeah, I see your time's up. Why don't you bring this up on rebuttal? Yeah.
Yes, thank you, Your Honor.
Yeah. All right, Mr. Marshall.
Good morning, Judge Niemeyer. May it please the court. I'm Kevin Marshall, representing the debtor. The grounds for affirmance here are quite straightforward. Everyone agrees the Robbins balancing test applies. Just requires a court to balance two things: potential prejudice to the estate against future hardship to the movants. And then that review of that balancing is then under an abuse of discretion standard, which is why this court has affirmed unanimously in all four cases it's decided under the Robbins test. Here, the bankruptcy court recognized its task under the court's precedent. It expressly carried it out. It gave reasons, and it made no error of fact. It did exactly what it should have done, very far from abusing its discretion. And I'd like to directly respond to your question, Judge Niemeyer, as well as yours, Judge Harris. The Manville case led to 524G. 524G itself identifies financial thresholds for qualifying for a plan. So Chapter 11 itself imposes no financial requirements, unlike Chapter 9 as well as Chapter 13. We get past that basic aspect of Chapter 11, we get to 524G. And what 524G says, what Congress actually enacted, distilling the general approach of Manville, was that 524G is available to a debtor who has been named as a defendant in asbestos cases, likely to be subject to substantial future demands for payment. The amount, number, and timing of those cannot be determined. And if we don't address this through a bankruptcy plan, we're not going to be able to resolve all of the claims. There's actually no dispute. One of the few things not disputed in this case is that we are in a situation where we qualify for pursuing relief under Section 524G. That is our purpose in pursuing bankruptcy. If we can't do it through a trust, then as you pointed out, Judge Niemeyer, the claims here will be liquidated differently. The whole point of 524G is to be able to consistently and equitably liquidate the claims across all of them. We have 30,000 current claims against us. That's just the active ones. Half of them have been lasting for are 10 years old. We have an untold number of future claims that will likely be in the thousands and run for decades. So if we grant lift-stay relief here, then what is the argument for not granting it in the next case, in the next motion to lift-stay? It creates a bind for the bankruptcy courts. The court below pointed this out.
What about the Seventh Amendment? That's the argument, that these folks have a right to a trial under the Seventh Amendment of the Constitution.
The second
And the bankruptcy court didn't address the allegation of bad faith for going into bankruptcy in denying his stay request, these stay requests.
Let me address those in reverse order, if that's okay, Judge King. The bankruptcy court actually did. So we're under the umbrella of the Robbins balancing test. Here, the basis for relief is not specific to these creditors. It's that the whole case is bogus. And this court has a rule for deciding whether the whole case is bogus, if I can use that term of art. It's the Carolyn standard. And under the Carolyn standard, if the case is not objectively futile, it was not filed in bad faith. But beyond that, the bankruptcy court here actually did consider the question of subjective bad faith in filing, and he spent 2 pages explaining why he was unwilling to find that here. But on the Seventh Amendment, Your Honor, there's no Seventh Amendment issue at all, and Mr. Ruckteschel effectively admits that in his brief, because there's a federal statute that says you have a right to a jury trial in a federal district court on your claim. But in bankruptcy, first you finish the bankruptcy, you set up the trust provides essentially a settlement offer, and if you turn that down, yes, you can have your trial. There's no Seventh Amendment problem here at all. That's how Section 524G plans have been operating since 1994. There's been over 60 of them. They always protect the jury trial right, and no court has ever seen a Seventh Amendment issue.
Can I actually just ask you to clarify something you just said about what the bankruptcy court did with respect to subjective good faith? You understand the court to have said, not I won't consider the question, but rather I am not willing to find subjective good faith on this record at this time.
He said, I can't find subjective bad faith in
Bad faith,
filing the
yes.
case. Sorry to use so many words.
Yeah.
Bad faith is kind of unclear. I can't find subjective bad faith in filing on this record and
At
in this
this time,
posture.
yeah.
And he spent 2 pages, that's J 921 to 23, explaining why, and I'll elaborate on that a little bit. The main argument, we hear the phrase subjective bad faith in filing a lot in this case, but that's actually just a label for 2 particular aspects of the case. The alleged lack of financial distress here, we actually do have financial distress, and I can come back to that, and the fact that before the bankruptcy, we did a corporate restructuring, just something that 524G contemplates. And what the argument is those 2 facts make what the bankruptcy court called per se bad faith in filing. Or in the opening brief, subjective bad faith in filing as a matter of law. That's a very odd concept when the whole question is, what is our motive? What was our state of mind? So it's not actually answering that question. And that's one of the reasons, and the primary reason, the bankruptcy court, I'm not going to find it on this record. But another aspect of it is, how are we going to know there was something bad about the corporate restructuring? Well, the argument is that it was a fraud. And the court said, well, I can consider that more fully in these 3 adversary proceedings I've authorized, and the whole point of those is to consider the state of the bankruptcy globally. And that makes a lot more sense than trying to adjudicate that question in the context of 2 individual claimants' piecemeal motions. And beyond that, in the corporate restructuring, and this is one of the ironies and oddities of this case, the argument is actually that we're insolvent. So here you're hearing we don't have financial distress. There you're hearing we're insolvent. And the judge is like, I don't know, but the better way to reach a definitive decision on whether there was a fraud is in these 3 adversary proceedings that I've authorized, and they're continuing on. Let me briefly talk about the financial distress. Again, it's not required by Chapter 11. It's not required by Carolyn. If the question is, do we meet 524G? I think it's actually undisputed that we do. But we've had 300,000 claims against us in the past, 60,000 pending, 30,000 active when this case was filed. It's undisputed there will be tens of thousands for decades to come. We spent $2 billion on asbestos litigation over the last 20 years. 524G, at least for its own context, defines what kind of financial problems Chapter 11 exists to address. We easily meet that. And it's not the case here that the bankruptcy court held we lack financial distress. It's not been resolved. Maybe it'll be resolved in the adversary proceedings. But it wasn't necessary to reach a full decision on that to deny the motions here under the Robbins balancing test. Again, prejudice to the estate balanced against future harm to the movements. What we essentially have here is an argument that prejudice to the estate should count for 0 because there shouldn't be an estate because the whole case is bogus. And that's where the Carolyn analysis comes in. And the court did it. It said case is not objectively futile. For purposes here, there's not subjective bad faith in filing.
Anything further?
I'll just address one other thing, which is the question of the next motion, which I briefly talked about with Judge Harris. I just want to point out that the motion here is a copycat of motions that were filed and denied in Bestwall and in Aldrich. There was 2 in each of them, and they're frankly copycats of one another. It's not hard from that basis to recognize that if this motion is granted, the bankruptcy judge will have no reasonable basis to deny the next motion. And there's 30,000 claimants who can bring that. We also know the basis for the motion here has nothing to do with the specific facts of a particular claim. That's the phrase of this court in the Bestwall decision. They're openly attacking the case as a whole, which means they're raising arguments that any of the 30,000 other claimants could raise. And then the last point,
All they had to show was cause, according to the statute, isn't that right?
they did have to show cause, and the Robbins balancing test explains what that means and how it's worked out. The bankruptcy court balances potential prejudice to the estate against future harm to the movements. It's done under the clear air standard for facts, abuse of discretion review.
If it's a good faith bankruptcy.
It is possible to seek to lift the stay by arguing that the bankruptcy case was filed in bad faith, which means, does it meet the Carolyn test? In this circuit, bad faith in filing bankruptcy is determined under Carolyn. It's undisputed, and that's the way.
Not a planned confirmation, right? A planned confirmation, Carolyn, is not the standard, is it? I thought a planned.
Did I say confirmation? If I did,
No, you
I was-
didn't.
oh.
You said in bankruptcy, and I'm,
The question whether the case was filed in bankruptcy is decided in this circuit under the Carolyn test. At confirmation, there's actually a statutory requirement that you need to propose your plan in good faith.
okay,
We're not there yet.
right.
Slightly
So
different.
you're not saying that at confirmation, Carolyn would apply?
Correct. If there are no questions, I have nothing further. Thank you, Your Honors.
Thank you. All right, Mr. Ruckteschel.
Thank you, Your Honors. With respect to the legislative history, Your Honor, when we look at the legislative history and the description in the report regarding the purpose for enacting 524G, Congress cites in its discussion of Section 111 bankruptcy court agendas, cites both the Kane versus Johns Manville, the Second Circuit decision that talks about Johns Manville being a financially besieged enterprise in desperate need of reorganization of its crushing real debt, both present and future. Right? So there was a crisis of liquidity that was facing Johns Manville that was going to cause the entire enterprise to collapse. And what the court then says, what Congress then
You
says,
mean crushing debt
yes, not from,
can be translated into insolvency?
so it wasn't insolvent yet.
I know
It
it
was
wasn't.
facing insolvency, and that was the financial
Well,
distress that allowed it to be
It
profitable.
was facing crushing debt, that's
Right.
what they observed. But the point was that is described in more detail about the nature of the number of claims, that they will keep coming, they're unpredictable, and they didn't know the amount. And Congress thought that is the stress, that the indeterminacy and the string out of the claims is what Congress was focusing on.
It was all anchored, Your Honor, however, by the fact that this was going to potentially cause Manville to collapse, right? The claimants are this is right from the legislative history, Your Honor. The claimants are ill-served if Johns Manville and other asbestos companies are forced into liquidation and lose their ability to generate stock value and profits to satisfy claims. And then 2 paragraphs later is when they talk about this being available for people facing overwhelming asbestos liabilities. So the legislative history is all tied. They cite to Kane, they cite to the description of the district court of the financial pressures, right? It's all tied back to the fact that there wasn't enough money. And that's financial distress, and that's what is the ultimate purpose of the bankruptcy code. If we look at the Bankruptcy Reform Act, and we look at the legislative history from 1978, Chapter 11, reorganization, the first sentence, Chapter 11 deals with the reorganization of a financially distressed business enterprise, providing for its rehabilitation by adjustment of its debt obligations and equity interests. You have to have a financially distressed business enterprise in need of rehabilitation. There is no dispute in this case that DBMP, Certainteed Stooge bankruptcy fall guy, is never and has never been in need of rehabilitation. It has It admits it has, and the bankruptcy court has found that it has, enough money to pay all of its asbestos liabilities in full. That includes present, that includes future. There is no financial distress here. If we look at how this court has interpreted financial distress, right? In Carolyn, the objective futility inquiry is designed to ensure there is embodied in the petition some relation to the statutory objective of resuscitating a financially troubled debtor. DBMP has never been a financially troubled debtor. It is not and never has been in need of resuscitation. To the contrary, the bankruptcy court found, and the debtor admits, that Old Certainty was a profitable, overcapitalized going concern that easily managed financially its asbestos liabilities in the tort system. It filed this petition for the purpose of paying less. That's not what 524G is about. It's not what the bankruptcy code is about, right? Judge Whitley found that specifically in paragraph 37 of his opinion in the preliminary injunction decision, which is in the record here and we've cited throughout our case. So there is no financial distress. Let's look how this court looked at financial distress in Premier Auto, right? Citing Little Creek from the Fifth Circuit. The purpose of Chapter 11 reorganization is to assist financially distressed business enterprises by providing them with breathing space in which to return to a viable state, right? DBMP has never been a financially distressed business enterprise. It has never required breathing room to return to a viable state because it has always been viable, right? As Old Certainties was. Not just viable, massively profitable. And there are findings in the record, in Judge Whitley's findings, that since the two-step, the Certainty Enterprise, which backstops DBMP through the funding agreement, has gotten only more profitable, Your Honor.
Yeah, you didn't file a motion opposing the petition, did you? Or did you?
No, my clients weren't even diagnosed with mesothelioma when this petition was filed.
All right, so it seems to me the time to raise that would be when you, when the petition was filed under Chapter 11 to oppose it. But here, the narrow issue is whether two claimants ought to have the stay lifted as to them. That's the issue, right? You pointed that out to us.
My time is up, may I respond?
Yeah, please. Yeah.
Okay. So, Your Honor, I disagree that that's the issue. The issue is, will there be harm to the estate as recognized in the concept of discussion of harm?
I thought the
cases?
issue was whether Judge Whitley abused his discretion in denying the stay.
It absolutely is.
And that's what's on appeal.
It's whether he abused his discretion and applied the proper standard of law, which he did not. And if we look at this question of
Well,
financial-
if he didn't apply the proper standard, he abused his discretion by definition.
Absolutely. But this court looks at misapplications of the controlling law and the code.
But the application for a stay, the motions for a stay, are reviewed for abuse of discretion.
Agreed, when the proper standard of law is applied.
And he missed it here.
Absolutely.
In how many respects?
So the court failed to enforce the burden of proof that's specifically allocated to the debtor resisting the motion to lift stay under 362G. So Congress has said the debtor has to come in and prove the lack of cause when it's raised, unless the issue is equity in the property, which is, everybody agrees, isn't that issue here. So for example, if we stick with this question of financial distress, which my colleague has acknowledged is grounds for lifting the stay if found, potentially, right, or bad faith is, then if the judge is unable to make the call, as Judge Whitley said, I can't determine whether it's a good faith filing or a bad faith filing, under the burden of proof allocated against the debtor, we win on that issue.
This goes back
The
to,
burden of proof was on the debtor.
Absolutely. That Congress has said so.
And the debtor didn't offer anything.
There was no evidence offered. There was no evidence of any harm to the estate. The debtor never produced any evidence saying if you allow liquidation of these claims, we won't have enough money to pay other people, right? That in full. There's no claim of that because it's been decided to the contrary. There's no claim, well, our executives will be distracted from reorganizing by having to follow what's going on. And they can't do that because DBMP is a passive holding company with no active businesses and one full-time employee who simply monitors what's going on in the bankruptcy case, right? So there's nothing to distract them from. They're not trying to reorganize because the Texas two-step did all of the corporate reorganization that would ordinarily happen in Chapter 11 before the petition was filed. That's why the Texas two-step compounds the bad faith so much, right? Because they've taken all of the reasons for Chapter 11 and just bypassed them. There's no need to resuscitate or reorganize a financially troubled debtor because they're not financially troubled and they've already reorganized. What they're using, as Your Honor pointed out in the decision earlier this year, they're using this as an opportunity to improperly invoke the automatic stay and to force judicially compelled negotiations by my clients
Counsel,
to
can
accept.
So in, I think, the first Bestwall case, I mean, I do understand your argument. In the first Bestwall case, though, right, we said, no, there's a perfectly legitimate business justification for this. Like, I feel that part of what the bankruptcy court was saying here is, as I'm reading the Fourth Circuit, this is not per se bad faith, and we know that from the first Bestwall decision.
I'm delighted that you brought that up.
I'm
right?
so glad to made your day.
Because Judge Beyer in the bankruptcy court specifically did not reach the question of subjective bad faith
Well, that's how you read it. I read it a little bit.
And this court, when discussing, I'm sorry.
No, go ahead.
This court, when discussing the preliminary injunction global lift stay motion that was the Bestwall 1 decision, as I'll call it, right, specifically says we are not faced with the question of whether this is a bad faith filing, and we're not faced with the question of the implications of a lack of financial distress. That decision expressly does not consider this, right? And there's a passing reference in Judge Quattlebaum's decision earlier this year that the bad faith issue has already been decided by the underlying court, but it hasn't, right? Judge Beyer specifically declined to reach the question of bad faith in the dismissal motions in Bestwall. Judge Whitley specifically declined to reach the question of bad faith in Aldrich Murray in a motion that I filed, right? This court has declined review of that question twice, both on the dismissal issues and on the question of bad faith.
Okay.
Neither the bankruptcy court nor this court has ever reached the question of the elephant in the room. Is this a proper use of bankruptcy? Thank you, Your Honor.
Thank you. We'll come down and greet counsel and move on to the next case. Next case we're in here this morning is APEC Atlantic versus Owners Insurance. And Ms. Dagger, whenever you're ready, we'll hear from you.
Good morning, Your Honors. May it please the court, I'm Kelly Margolis Dagger. I represent the appellant, APAC Atlantic. The district court applied the wrong law to conclude that APAC was not entitled to coverage as an additional insured for liability arising out of Emory's work for APAC. In doing that, the district court also overlooked undisputed facts that, considered under the right standard, would show that APAC's liability did arise out of Emory's work for APAC. 2 motorcycles crashed in western North Carolina, leaving 1 driver dead and 2 injured because Emory put the wrong signs in the wrong location on a paving project that APAC was involved in. APAC was the prime contractor. It is undisputed that Emory installed uneven pavement signs on that project as a subcontractor for APAC. The underlying plaintiffs, the parties who were injured and their representatives, sued APAC. APAC paid a settlement in that case, and that liability arose out of Emory's work for APAC. So APAC is entitled to coverage under the plain language of the owner's policies at issue in this case.
Is it undisputed that the subcontractor installed both the work zone signs and the uneven pavement signs?
Yes, Your Honor.
And is there any evidence that the contractor installed those signs?
The prime contractor being
Yes.
APAC? No, the prime contractor did not install the uneven
Well, that's what
pavement
I assume.
signs.
So your argument is just simply that because liability in part is alleged because of the misplacement of the signs, therefore APAC's liability arises out of the work of the sub.
That's right, Your Honor, but I'm going to add one thing to that. Because that's alleged, but also because in the underlying lawsuit, the plaintiffs offered evidence to support that allegation.
Well, it's not disputed, I don't think, in this record.
I don't think it is either,
Yeah.
Your Honor.
All right. Is there really any more to your claim?
I wouldn't say so, Your Honor. No, it's that simple, that it's
I
not.
mean, it doesn't
disputed.
depend on whether there's contributory negligence or whether there's master servant or any of that. This Pulte opinion basically says all you have to do is look out at whether it's arising under that work.
That's right. I agree with that, Your Honor. And the district court just got it wrong. The district court relied instead on an Ohio case, and the Ohio case sets a different standard for what arising out of means in an insurance policy that actually does require a showing of the named insured's negligence, which, as Your Honor noted, Pulte does not. So the district court got it wrong by relying on that different Ohio standard. The North Carolina Supreme Court has made it clear arising out of is a broad standard. It's ambiguous in an insurance policy, so it's construed in favor of coverage. And it doesn't require a showing of negligence by the named insured. It also doesn't require APAC to disprove its own negligence. Because the record is replete with, what, again, we contend to be undisputed facts showing that the subcontractor, Emory, did install these uneven pavement signs and put them in the wrong place, that's enough under North Carolina's more generous standard to show that APAC's liability arose out of Emory's work for APAC and entitles APAC to coverage under the policy. I'll just touch briefly on the district court's factual analysis. So as I've said, the district court applied the wrong law. Applied that
So
Ohio
what are you
law.
trying to persuade us now about?
Well, Your Honor, I'll be very direct about this. I'm the appellant, and I'm trying to persuade this court to reverse and remand the case for
I
entry of judgment
understand, but you
in favor
just
of
asserted
APAC.
to me that the facts were undisputed, and I seem to think so too. I read the record, I read actually the testimony, and it looks to me like Emory installed both the work zone signs and the uneven pavement signs, and that those signs were allegedly in the wrong spot.
Yes, Your Honor.
And the liability of APAC arises out of the placement of the signs.
I agree, Your Honor, and so
So
with,
now, what more do you need to argue about the facts?
well, with that, I'll just reserve my remaining time for rebuttal and ask the court to reverse and remand for entry of summary judgment in favor of APAC. Thank you, Your Honor.
All right. Mr. Bolster?
Thank you, Your Honor. May it please the court, Jeff Polster here for Owners Insurance Company. Looks like I got some work to do. In 20
Well,
minutes.
I assume you agree with the fact of what Emory did at the site and placing both the work signs and the uneven pavement signs, and that Apex liability is alleged to be in part based on the misplacement of the signs, right?
To an extent, Your Honor. These accidents, the death and the severe injuries had nothing to do with the work of Emory Silco.
Let me ask you, did they have anything to do with the placement of the signs?
Your Honor, JA 458.
Now, just answer my question. Did
Not the sign that Emery Seal Co. was hired to install and didn't.
I understand that. You know, you're obfuscating. The contract they had was work zone signs. They didn't, it wasn't the uneven pavement signs.
Correct.
But there was an agreement, oral agreement, to put in the uneven pavement signs. That was not disputed, and there was actual payment for that, additional payment to put in those signs. So factually, are you disputing the facts that Emery put in the uneven pavement signs?
I am not, Your Honor.
All right, well, and the liability in this case arises in part out of the placement of the signs, right?
It doesn't.
I thought the allegation was that there were two contributing factors to the accident. One is the placement of the signs, and the other was the failure to put a ramp on the pavement to, I don't know what you call it, a flange or on the edge of the raised pavement. But both were alleged, and both were discussed. I don't understand where you're coming from, that the signs had no play in this case.
Your Honor, if I may, and I'm sorry if I'm going to push back about obfuscation. I can assure you, this is my first time before this court. I've been doing this 30-some years. The last thing in the world I am going to do is come to the Fourth Circuit in Richmond, Virginia, and try to confuse or obfuscate these facts. But I would like to very much focus on what I think are the key issues. Emery Seal Co. was initially hired to do a very limited amount of work for $44,250 of a $13 million project. They went out there, they were hired to do work zone advanced general warning signage. That involved road work ahead signs, begin road work signs, and end road work signs. Those were stationary signs. They're set forth in the drawings. There was nothing in any of the drawings that said anything about uneven pavement or uneven signs. What happened was, and there's no dispute that that work was done properly, that $44,250 worth of work was done properly. Right before paving began, a DOT representative named Mike Patton on August 3rd, 2018 approached APAC and said, before this paving can even begin, we need you to go out and put uneven pavement signs. Now, you remember in the briefing, there's talks about uneven lane and uneven pavement signs. He never said go put uneven lane signs. He said, APAC, go put uneven pavement signs out there. APAC came to Emery Seal Co. on August 3rd of 2018 and said, you need to go put uneven pavement signs out there because we can't start the paving until you do. That was nowhere in the contract. It wasn't in line item 13, it wasn't in line item...
You had a side deal.
Sorry, Your Honor?
You had a side deal.
We had a side deal.
Or an oral agreement, or an oral deal. You made a side deal.
That's right. So we got to stick to the terms of the side deal. And if you look at the evidence in the record, in Chad Emery's deposition testimony, he said he was told where to put the signs, what to do with the signs, and what signs were there to use. And in fact, the DOT was out there instructing him on where those signs were to be placed. He never consulted with line item 14. And this is the key of our case, is the distinction between line item 13 and line item 14. We were hired to do 13. These additional uneven pavement signs were stationary signs that would have been part of, or a modification of 13, not of line item 14. Line item 14 was the signage requirement for the uneven signs that APAC was responsible for. APAC never delegated responsibility for line item 14 because they couldn't have. Because under the facts, under the diagram, and under the contract, under TC2 and TC4, if you look at the footnote...
Well, are you saying there are disputed facts then?
No, not material facts.
Your colleague on the other side said the facts are undisputed.
We're not saying there are material facts in dispute, Your Honor. I'm saying that subsequent...
But you don't agree what those facts are.
Well, I believe efforts are being made to blur the distinction between line item and 13, line item 14. And
I guess I'm trying to think of a nicer way to put this question than who cares, because we're talking about the sort of oral agreement, which
Right.
was put up the uneven pavement signs, and they apparently did it wrong, and hence the liability. So I guess I'm also not seeing what is hard about this.
First of all, they didn't do it wrong. They did it exactly according to the oral modification.
But there's no negligence required under Pulte.
I agree, I totally
The
agree.
idea is just whether the claim arises under the work
I agree.
performed, and the work was performed by Emery.
Not the installation of the uneven sign.
Emery put those signs up.
They put the
Wait,
stationary uneven pavement sign that's located in this Exhibit J.
Let me ask you this, were any signs put up by the general?
No, but they were
All right, all the signs involved in this case were put up by Emery. And the question is, is this arise out of the work of Emery, which was to put up the signs? I don't know, we're not talking about negligence and contributory
No.
negligence. The North Carolina cases have made that clear. So I don't understand where you're headed. I'm willing to listen, but you're sort of suggesting that Emery didn't have any liability because they were following instructions. But they put them up where they put them up.
All right, can I convey something very important to me? I keep showing the court this diagram. You've probably seen it, JA 458. That's the whole crux of their case. They're saying these signs, there's nothing wrong with these signs. These signs didn't cause the accident. They're saying there should have been signs down here, right? They're saying, you guys.
I'm not saying anything. You're talking about whether it's negligence, whether it caused it, whether the result was it, but the claim, the allegation was pretty clear that there were two true contributing factors alleged to cause the accident. One was the absence of a lip coming off the higher pavement, and the other was the placement of the signs. There were no uneven pavement signs before the uneven pavement.
We were not hired to place the uneven
It's
signs.
not whether you hired, it's whether you did the work.
We didn't do the work. We weren't asked to do the work. Under the contract,
All
Your
you
Honor.
have to do is to be the one that placed the signs, and you just agreed with me, they placed the signs.
But that sign didn't cause it. It was the absence of the sign upstream that caused it, and that was APAC's sole responsibility that they never delegated
So
on.
so you're, so.
What
and
your
you're-
argument is, you need a trial then?
I think Judge Cogburn got it right.
You want to affirm Judge Cogburn?
Absolutely.
Just so I
Absolutely.
understand, your understanding of what happened is that APAC delegated, said, you put up all of the signs except for one. We're going to put up the first sign, you're going to put up all the others every quarter of a mile? That's what happened?
I'm really asking the court to focus.
Can you just answer, is that what you are saying
Yes.
happened?
APAC had independent responsibilities for signage, and that's what's so confusing
But
about
that's
this
their
case.
But that's
negligence,
right,
maybe.
that's-
That's their negligence, but the Supreme Court, the courts in North Carolina have said it does not depend on the negligence or relative negligence. It depends on arising out of the
Right.
work.
That work was never delegated to Emory Seal Code to put those signs in another location. Okay, if I can read the footnotes under J95, that's where the uneven signage is. It says that milk areas are not paved back by the end of the workday. Portable signs shall be used to warn drivers of the present conditions, including rough road, uneven lanes, and grooved pavement. These portable signs are incidental to the other items of work included in the temporary traffic control lump sum pay item. And that's what I have tried to emphasize in the brief, and what I am going to do everything I can emphasize with a limited amount of time here. They were paid $630,000 to do part of the signage. They were. And that's what's confusing. They're trying to say all of the signage because you had responsibility for part of it, then you, therefore, if there's something went wrong with the signage, it arose from your work. It did not arise from our aspect of the signage. They had an obligation as a general contractor when these elevations were up, and this was 2 or 3 weeks after these signs were put up, where there's milling going on, and if it's kept more than 2 inches or 2 inches or less for more than a day, they have an obligation by the end of the day to put a temporary sign up that says uneven lanes. That was never, ever delegated to Emory Silco, and it couldn't have been. We were never brought back out. We did the advance warning signs before the project ever began. They were the ones on site. They were the ones that monitored it, and every time there was, if they went home for the evening and there was a 2-inch or less lip, they had a responsibility to put that additional portable signage up that said uneven lanes. And they had a duty, when the condition was mitigated, to remove the lanes. It was an ongoing, evolving job site that we were never asked to deal with or never asked to participate in. We didn't come back. It was a general contractor. They were paid $630,000 for temporary traffic control, and this was part of their responsibility. And they never delegated it to us, nor could they have, because we were not on the site on a regular basis monitoring it. We were never asked or hired to accept responsibility for this portable signage. It was a day-to-day, week-to-week thing that APAC and APAC alone was responsible for. That's where it didn't arise from these signs. These signs didn't hurt anybody. What happened, it arose from the work of APAC. It was APAC, and APAC's alone responsibility for putting these portable signs up every time the 2 inches of pavement.
Well, it says
was
here
left
that,
over.
it says here he was asked to put up near the beginning of the job and then every half mile, put those signs up. That's what he was instructed to do, and he agreed to do it.
And he did it.
And he didn't do it.
He did it. He did it. All of the evidence in the record is that he put the signs where he was asked to put them. Those uneven pavement signs were not uneven lane signs. They were not intended to address the ongoing issue of, okay, we're milling it, there's a height differential. If we go home tonight, we've got to get signs out that say there's uneven lanes. That's not what we're talking about here with the uneven pavement, and there's an effort to confuse the uneven pavement and uneven lane signs. That's not, that uneven lane responsibility was never, ever delegated by APAC to Embry-Sealco. I wouldn't be here today if it was. But it's a really, really important distinction that I obviously didn't make clear enough in my brief, but that I focused almost exclusively on that, and I'm sorry it wasn't clear, and I'm doing the best I can here today. We've got a general contractor who was paid a lot of money on a project, and is now, you know.
How much was Emery paid for the uneven payment signs?
We don't know that, Your Honor. It's not in the record. We don't know the amount. But we've got a general contractor who's paid over $13 million for a job. They had portable signage requirement. That's the only place the responsibility was for the uneven pavement signs that were not there. We never came back out. We were not asked to do that. That was not delegated to us. And I would submit to the court, how could this arisen from the work of Embry-Sealco?
Now, you say there wasn't a sign before the uneven pavement?
There wasn't.
Well, the guy from Emery says he was instructed to put near the beginning of the job and then every half mile.
Correct. And he did
Well,
that.
isn't that his work then?
That part of it is.
Well, and you said there wasn't a sign put it near, and yet he had the response near the beginning.
Well, keep in mind, that sign was installed August 11th. The paving began August 19th, 8 days later. The first accident happened September the 1st. So when they put the uneven pavement signs there, there was no uneven pavement whatsoever. There was no uneven lanes whatsoever. The paving hadn't even begun. So, yeah, he testified that he was told to put them at the beginning, near the beginning, and every half mile or so, nothing exact, and there's no dispute that he complied with those responsibilities. But that's not the same thing as APAC's responsibility to put portable signs as the conditions dictated at the job site. And it wasn't every day. It was when there was a height differential of 2 inches or less. That's when the danger was created. That's when they had an obligation at that time, if they didn't bring it up to level by the end of the day, they had to have people on site and put these temporary portable signs saying uneven lanes. And then once the condition was mitigated and it was flat, then you take the signs away.
No, this is what he says, and I don't know how you interpret that, but Harrison, you gave, so-and-so gave you, that's Emery, the instruction to place uneven pavement signs beginning near the beginning of the work area and then every half mile, both eastbound and westbound.
Correct, Your Honor.
Now, and you tell me those signs weren't there.
Those signs were there. But there was no,
But near the beginning, eastbound and westbound? I thought you just told me about a few minutes ago there wasn't a sign at the beginning.
It was near the beginning, is what he was told to do, and there was a sign near the beginning. You've seen the photograph. That sign is near the beginning.
And every half mile, but near the beginning in both directions, east and west.
Correct, and there were. Your Honor, the oral modification was complied with, the item 13 was complied with. And I understand, if it doesn't have to be,
Well, I'm missing the boat here. You just told me a minute ago there was signs that were not put up. And I'm trying to figure out, it looked to me like all the sign requirements were signed to Emory, including the uneven payment signs. And not only uneven payment signs, but uneven payment signs before the work, going eastbound, and before the work going westbound, and every half mile thereafter. And you say they weren't all there. Which one wasn't there?
all of the portable signs showing that there was.
Now, which one
uneven
wasn't
lanes.
there? You say one wasn't there.
If I did, Your Honor, I'm saying that he did everything he was asked to do. He put the sign near the beginning.
So it's near the beginning, but inside
Right.
and not before? Is that what you're saying? They were near the beginning, but not
Correct.
before?
And keep in mind, there was no paving going on when this was installed, right? And he said, he goes, I would have had no way of knowing where this was supposed to go. I was told by the DOT inspector to do this because it's not part of the specifications. And you rightfully said, well, you're right, it's an oral modification. So he didn't have specifications to look at to determine where these stationary uneven pavement signs would go because they're not in the specs, they're not in the contract. It's an oral
I know
modification.
but you're sort of arguing the liability and the merits, and this coverage question is assigning territory, so to speak, of coverage. And the idea is that APEC is protected from any work that is performed by one of its subcontractors. And
Right.
in this case, all the signage work was done by Emory. All the signage work that was done by Emory. And it's the signage work that's being criticized. Now, the question is whether Emory did it correctly, or whether they followed instructions, or whether APEC was contributory negligence. I think the Supreme Court, I don't know if the Supreme Court, could be other courts, but the courts of North Carolina seem to suggest that doesn't play into the analysis.
Yeah, I'm run out of time and I don't have any.
No, I'd like to address it. In other words, you seem to suggest it depends on the negligence or not, or what does it depend on?
The signage component of this lawsuit, okay? If there was a signage deficiency that caused these accidents, it was the failure to install signs once the uneven pavement was created, once the uneven pavement wasn't corrected within 24 hours, to notify approaching motorists that there was current existing present conditions that were dangerous. That was the responsibility of APEC.
You say APAC's the one that was at fault.
100%.
But it doesn't matter who was at fault.
I
I
know.
just think you're reading arising under to mean caused by, but that's not what it means. It
It
means
arises out of
there
your
has
work.
to be some kind of a causal connection. It can't be, and the language is really broad. It can't be wholly disassociated from, independent of, and remote from Emory's work with respect to the signs. And I don't see how what happened, the settlement here, is wholly disassociated from and remote from Emory's signage work.
It has to arise from Emory's work.
Well, I just read you how the
Right.
North Carolina courts construe that. I think you are reading, and I think the district court did too, reading arising from to mean caused by, at least in some sense, but that's not what it means.
There has to be some causal connection. It doesn't have to be to the level of proximate cause. There has to be some causal connection, and there simply wasn't. And I'm going to sit down, and the last thing I'm going to say is line item 14 was their responsibility. That is the signage defect that's at issue in this lawsuit. They're the ones who are responsible for it. It was an absence of signage that they failed to do, not the signage that we installed, or that Emory Silco installed. Thank you.
Was this on Route 74?
Yes.
Well, what's references to Route 17?
Um,
I think briefs got references to Route 17
Okay.
and Route 74 both, and almost interchangeable. Can you explain that?
I can't, Your Honor, I apologize.
I was confused by that.
Yeah, I don't have that,
That's all right.
I apologize. Thank you.
All right, I wish we could come to understand a little more what you're arguing, because you're obviously frustrated, and we want to fully understand it. But
Sure.
I think our pushback here is to have you recognize the breadth of the arising under goes beyond the relative negligence of either party. And
I understand it.
and it's not line 14 of the contract, it's line 14 plus the agreement that they made, the side agreement they made at the beginning of the project.
I agree, Your Honor, but that sign agreement didn't include uneven lane signs.
No, it included uneven pavement signs.
Right.
And I think that's sort of immaterial, because the signs, if they were the wrong signs, it's still the work of Emory. If Emory put up an uneven pavement sign and you say it should say uneven lane sign, that's still their work, right?
Yes, Your Honor. It was the failure on Apex's part to put the portable uneven lane signs is what's the issue here. It's not the permanent stationary sign that was installed.
Now, the testimony where they talked about was uneven pavement signs.
They go back and forth on that, but you're right.
Yeah, okay. All right. Well,
Thanks, sir.
Thank you. All right, Ms. Dagger.
Thank you, Your Honor. Judge King, to your question, my co-counsel, Mr. Malone, tells me that Highway 17 and 74 connect somewhere
Connect?
out there. They connect somewhere, and that may be the reason for the variable references. I hail from the eastern part of the state, and I don't pretend to be an expert on that roadway.
You don't know.
I'm not an expert on any roadways, but I can get from Raleigh to Richmond. Your Honors, just briefly,
If I understand the argument, and I'm trying genuinely to understand it, the argument is that the work relating to signs was divided, and not all of it was given to Emory, and part of it was retained by APEC. And this arose out of the part that was not given to Emory somehow. I think that's the argument.
I agree, Your Honor. I think that is the argument. And we contend that the argument really that the district court accepted and that owners is making is one that goes far beyond what North Carolina law requires when we're asking whether the liability is one arising out of the work of Emory for APAC. So the fact that APAC may have been able to do something different or additional, or maybe should have done something different or additional.
Well, they were required to put in signs, but it seems to me, in reading the record, they were hired under line 14 to put in work zone signs, and for $44,000, and they did that. And then, before the project, when there was additional signage required, regardless of what it was, APEC didn't take that on itself. It gave that to Emory, which seems to indicate that the relationship between Emory and APEC was that all signage would be taken care of by Emory, because there was no signs put in by APEC, and they never assumed any to do that work themselves. They intended to subcontract it out. They only contracted out the work zone signs in the contract, and they added, when it became necessary for additional signs, uneven pavement signs, they again had Emory do that instead of doing that themselves. So I'm not sure there's any evidence that there was divided work, that APEC retained signage responsibilities. I think the work
Was done by Emory,
Yeah.
and
all signage work.
effectively, all signage work was done by Emory. I think it's a different question.
Did you say effectively all?
Sorry, let me just take out effectively. All the signage work was done by Emory. I think it's a different question whether every bit of signage work contemplated in the NCDOT contract was done. So it's a different question whether And that's where I think owners is pointing to the NCDOT contract and saying, here are all these requirements for signage.
You
APAC.
mean all the signs that were needed weren't put up? Is that what you mean?
Right, I think that's what owners is saying. They're saying, well, there should have been even more signs put up.
Well, I
But
don't
all the
quite
si-
understand that. I thought it was a misplacement of signs because the description by the Emory representative was that he was told to put up uneven pavement signs near the beginning, both eastbound and westbound, and every half mile
That's right,
through the project. Now,
that's right.
was there any other signage required? Any evidence of any other signage required?
Well, so Emory put up various other work zone advanced warning signs.
Well, I said those
and-
were work signs that they had, but
That's
they
right.
had the full responsibility for that too.
And so here's what I think.
Well, what was the side deal?
Well, the side deal was, as Mr. Emery testified in his deposition, to put up uneven pavement signs at the, near the beginning of the project and every mile thereafter, half mile. And that matches line item 14 in the NCDOT contract, which deals with the rest of the signage. And so and Mr. Emery testified, he didn't look at that contract, but if he had, he would have seen it said, the signs need to start before the uneven pavement. And Mr. Emery testified he knew where the paving was gonna start. It's not like there was a bait
So
switch on that.
you're focusing on really what Judge Harris just asked about near the beginning.
That's right.
Is not precise enough. It had to be near the beginning, but before. Before instead of after the beginning.
Sure, so if owners is saying, and Your Honor, I'm gonna run out of time.
Is
Could I
that the
answer that
deficiency?
question? Could I exceed my time and answer
Yes,
that question,
go
Your Honor? Yeah, I mean, that may be what owners is saying. It may be that they're saying, okay, well, the oral modification was just near the beginning, and we did this near the beginning, but Mr. Emery said they knew where the paving was gonna start, and he admitted that the first sign they put up was after that. And the accidents happened, at least in part, because there was no advance warning of the uneven pavement. So that's Emery's work in placing those signs along the roadway and starting too late. It's that simple.
All right.
Thank you, Your
Thank you.
Honors.
You would take a break? Do you need a break? Okay, I'll take a break too. All right, we'll come down and greet counsel and then take a short recess.
This honorable court will take a brief recess. United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. All right, next case we'll hear this morning is Allen versus Stein, and Mr. Brode, we'll hear from you.
Good morning, Your Honors, and may it please the Court. My name is Nick Brode. I'm in the North Carolina Department of Justice, appearing on behalf of the defendants. This case should have ended 5 years ago. 5 years ago, the United States Supreme Court unanimously affirmed this court's decision holding that North Carolina has sovereign immunity from Allen's copyright claims. Back in the district court, Allen then voluntarily dismissed with prejudice his remaining claim against the one defendant left in this case. That should have marked the conclusion of this litigation. Yet the district court below reopened the case and allowed Allen to file a second amended complaint asserting a claim under United States against Georgia, a claim that Allen could have brought all the way back in December 2015 when he originally filed this lawsuit. The district court's decision to reopen the case and allow Allen to file an amended pleading was error. The district court also erred in holding that Allen plausibly alleged a violation of the Copyright Act that also violates due process. For either reason, this court should reverse. There are two orders that are before the court. They're distinct but closely related. There's the district court's 2021 order reopening the case and allowing Allen to amend, and then there's the district—
Can you explain to me how
Yeah.
we have jurisdiction over that
Yeah.
first order?
Your Honor, the court has jurisdiction over the 21 order because the district court in its 2024 order denied in part our motion to dismiss based on sovereign immunity. That is a 1291 final decision. I think everyone agrees that we were allowed to immediately
It's not a
appeal.
final decision, is it? I thought it was, it's a decision over, the sovereign immunity decision is a decision over which we have jurisdiction, I thought, under collateral order doctrine.
Your Honor, the 2024 order is a final decision under the collateral order doctrine
Okay.
that allows us to be here.
But we
And-
have held that even when we have, when we can hear an interlocutory appeal of the denial of sovereign immunity, that doesn't mean we have pending jurisdiction over other issues in the case.
Your Honor, I think the 2021 order as a prior, earlier procedural order that led up to the denial of our motion to dismiss merged into the 2024 order. So I don't think this is a pendant appellate jurisdiction kind of a situation. We're not here asking you to review, for example, another claim that we couldn't have otherwise appealed, or another defense like personal jurisdiction or statute of limitations or state law claims that wouldn't otherwise be properly before the court. The 2021 order is an earlier in time procedural ruling leading up to sort of inevitably the 2024 order. The reason the 2024 order exists is because in 2021, the district court said, I am going to reopen the case and permit Mr. Allen to file a pleading that would pierce the state's sovereign immunity. And so in that sense, I think the 21 order and the 24 order really are sort of functionally one big ball of wax here that allows the court to review both orders at the same time. Because again, I don't think there's any dispute that the 2024 order is properly here. It is a final decision, and as the Supreme Court explained in Puerto Rico Aqueduct, it's a final decision because it conclusively resolves a very, very important issue for the state of North Carolina. It holds that we're going to have to face suit, and sovereign immunity is all about an immunity from suit, not having to face the burdens of litigation. And it would seem odd, I think, given the important interests that are at play here that are recognized in the district court's 2024 order, to say, well, we can't review sort of the logically antecedent question of whether Mr. Allen could have even asserted a Georgia claim in the first place. Because
That's what allowed him to do the 2021 order authorized proceeding on the Georgia claim.
That's correct.
And that's the seed of what you say is the error that got us here.
That's right. That's right.
Final error.
That's right. That's right. The 2021 order, that's exactly right. It's the seed. It's sort of
But you're saying the 2021 order should never have been entered.
That's right. That's right. The 2021 order should have
That was
never—
an erroneous decision.
That was an erroneous decision. It was an erroneous decision because the district court reopened this case under Rule 54B, even though the case was over. So Mr. Allen himself in the district court when he sought to reopen the case, filed a motion under Rule 60b-6. This is at JA page 58. But the district court looked at that and said, no, I'm going to construe this as a Rule 54b motion instead. And as best I can tell, the district court reached that conclusion because it thought, well, there's not a piece of paper in this record that says final judgment. And there is no such piece of paper on the docket that says final judgment. But the reason there's not that piece of paper is because Mr. Allen voluntarily dismissed with prejudice under Civil Rule 41A1A, Romanet 2, his remaining claims. And that piece of paper, the minute that piece of paper hit the docket, the case was over. There was no claim against any defendant left.
I mean, does it matter, in your view, which rule the question is considered under? I mean, do you think it could have been properly granted under 54?
I do not think this could have been properly granted under Rule 54, given all of the very unusual features of this case and the prejudice to the defendants from having to face for the first time a claim that Mr. Allen could have originally pled when he filed the lawsuit. But I do think the number matters quite a lot because under Rule 60b-6, of course, Mr. Allen would have had to have shown extraordinary circumstances. And I don't think Mr. Allen has come anywhere close to showing circumstances of that kind. I mean, the district court reasoned that this court and the Supreme Court had passed on this Georgia issue, but this court in its 2018 decision said nothing about Georgia. It cited Georgia sort of in passing. The U.S. Supreme Court did not.
In what case? When did we not say anything about it?
In your 2018 decision.
The 28, one that went to the Supreme Court.
The one that the Supreme Court
Well, we
unanimously
cited it
affirmed.
in there.
You cited it. You cited it. But you did not substantively discuss a Georgia claim. And Mr. Allen at the United States Supreme Court conceded that he did not bring a Georgia claim. This is at page 32 of the oral argument transcript before the United States Supreme Court. He acknowledged that
Was
there
that
was
ruling in 2021 reviewed for abuse of discretion or de novo?
It is reviewed for abuse of discretion, but because the district judge committed an error of law, it is categorically an abuse of discretion.
What was the error of law you're alleging?
I'm alleging that the district court erred because it applied the wrong civil rule. The district
54?
Right.
Instead of 60?
Instead of 60, yes, yes. And I think in some...
That would just be a clerical error. A misnomer.
No, Your Honor, I think the sharp difference in the relevant standard under Rule 54B and Rule 60B means that this is much more significant than just a clerical error. Because again, Rule 60B requires extraordinary circumstances, and I don't think we're anywhere close to
What's the standard under 54B?
So Rule 54B is a more forgiving standard for revising interlocutory judgments. It permits the district court to revise interlocutory judgments for things like newly discovered evidence, a change in decisional law, or some other important issue of justice.
Which of those would be
Well,
even
exactly.
implicated here?
Exactly. I mean, I think I can win under Rule 54B even if you were to assume that that rule were to apply. I think even if Rule 54B applied, this would still be an abuse of discretion because, again, Mr. Allen could have raised a Georgia claim back in 2015. In 2015, Georgia had been on the books for 10 years. And it was a fully available precedent of the United States Supreme Court.
There's clearly no new law or fact. I mean,
That's right.
so it'd have to be that third bucket?
I suppose, yeah, I think that's right. I think the only way if we're accepting 54B as the standard, the only way Mr. Allen could have succeeded was this third sort of amorphous bucket about, interests of justice. And again, I just don't see anything on this record to indicate that the district court could have acted within its discretion to revive the case under that rule. Because as I was saying,
Could you say he couldn't have exercised his discretion to reopen the case, period?
That's right.
There is no rule. There's no provision that would warrant this in these circumstances. Is that your position?
That is my position.
That's the position of the state of North Carolina.
Yes, Your Honor. Yes, Your Honor. This case should have been over.
It seems to me your argument is more persuasive to go that route that Judge King just asked, because Allen did file a Rule 60 motion, and the court treated it as a Rule 54. And he asked for a 60 motion.
That's right.
And your argument is that that has a higher degree of which he couldn't satisfy. But you also argue that the court lowered the standard by using 54
That's right.
At Rule 54, and under that standard, you still should not have had a reopened
That's
judgment.
correct. That's correct. Yes, that's correct. And I mean, again, nothing had changed in,
And disregarding the rule citations,
Yeah.
what's your best argument that this shouldn't have happened, that it was an abuse of discretion? Time?
it's the prejudice to us from the passage of time.
It's a prejudice. Well, I don't know how you'd be prejudiced. How would you be prejudiced?
Well, so I think there's a number of
State of
ways.
North Carolina be prejudiced?
So, I mean, we defended this case all the way up to the United States Supreme Court and won a unanimous victory.
It went through the whole process that's available.
Yes, it
And-
went through all.
And the Supreme Court, Judge Niemeyer wrote a great opinion, and the Supreme Court recognized it, and that should be the end of it.
Yes,
That's North Carolina's position.
yes, yes, that's our position. And of course, I mean, you know, I think it's worth maybe putting a little bit of a finer.
Basically, your argument comes down to the law generally doesn't like a second bite.
Exactly.
And this is a second bite because there's no new developments.
That's right, that's right. It's a do-over. It's a request for a do-over, and there is no compelling reason to give Mr. Allen a do-over on these facts. Georgia has been around since 2006. It could have been asserted all the way back when he originally filed his complaint.
To find an abrogation under 14th Amendment after the Supreme Court went through the statute
Yeah.
with respect to the Copyright Act would be a
Yeah.
strange bird. I would think Justice Kagan would say, "Didn't you hear us?" Well, I don't know.
The court might. I mean, I agree with you that it's an unusual, we're in an unusual procedural posture. And I think that is a result of errors that the district court made in how it applied Rule 54B, even if you accept that Rule 54B is the proper standard. Because again, I think it is worth underscoring that Georgia was never in this case. It really was never cited to this court in the briefs when this case was here last time.
Well, you'd do better if it was cited, and it was, we did cite it, but you do better because the point is, it was around, people knew
Exactly.
around it. If they had that theory, they could have raised it.
That's right.
I don't know if a case has ever decided a copyright or a patent right is abrogated under the 14th Amendment.
There's very limited precedent on a Georgia sort of as-applied abrogation theory in the copyright context. And I think that maybe is all the more reason to be attentive to the procedural irregularities here. I mean, you know, Georgia, as best I can tell, was substantively discussed for the first time in, I think, an amicus brief.
What was your theory why 54B? Is that because it's too late? It was inappropriately applied because it was too late, or what?
I think if you're proceeding under Rule 54B, my argument would be there hasn't been any change in the evidence. There's no new
Well,
facts.
you're addressing the substance. I mean, the motion was filed, was it timely? The judgment was August 17. The court, when did the court address 54B? What date?
Well, the court's 2021 order addresses Mr. Allen's motion to reconsider under Rule 54B. Mr. Allen filed that motion in September of 2020.
I thought there was a motion under Rule 60.
Right. Mr. Allen
He filed it in September under Rule 60.
under Rule 60. That's correct.
But my point is, if we're looking at the procedure, the court applied it. Well, I don't know, what's the theory, what's the procedural problem? And I guess it's timely if you consider the motion, the 60B motion to be a 54B
Right.
motion.
Right.
All right.
Right. I think that's how you would have to think about it, is that no, the 60B motion in effect
So
was a
procedurally,
54B.
there's no real issue. The issue is, you're arguing procedurally, the issue is that they asked for a standard that couldn't be satisfied, so the court changed the rule and gave them an easier standard.
That's right. That's right. The court gave Mr. Allen a do-over to assert a claim that he could have raised 10 years ago. And now that we're 10 years after the filing of the original complaint, 5 years after the U.S. Supreme Court decision, we're 12 years now away from the settlement agreement in 2013 that gave rise to a lot of this litigation. Witnesses move, memories fade. We've defended this case all the way up to the United States Supreme Court. There's clear prejudice to us from continuing a case that should have ended.
Where were you in 2017?
Where was I in 2017?
Were you with the state?
I was not. No.
This is even before your birth, before the
Yeah, it was a long time ago, and I mean, I don't remember what I was doing in 2015 or 2013 when the settlement.
Did you
agreement was reached.
litigate this thing in 2021 to 2024? Or did you just cover it up here on appeal?
I'm involved in the appeal, yes, Your Honor.
You're the appeal guy.
Yes, Your Honor.
All right, anything further?
I have nothing further.
All right.
Thank you so much.
We'll hear from Mr. Adler.
Thank you, and may it please the court. My name is Adam Adler, and I represent appellees Rick Allen and Nautilus Production. This appeal is about complex questions with simple answers. In my argument today, I'd like to highlight 3 issues that simplify the matters in dispute and provide the best path to resolving this appeal. First, the court lacks jurisdiction over defendant's Rule 60 procedural issue. This court already held that the challenged order isn't final and doesn't fit under the collateral order doctrine. Defendants rely on the merger doctrine for jurisdiction, but that fails since interlocutory orders don't merge into each other. Second, on the merits of the procedural argument, this isn't a do-over. Georgia was in the case from the start, and the district court applied Rule 60, Rule 54, and Rule 15, and found that plaintiffs' requested relief for reconsideration satisfied the requirements of all 3 rules. Plus, there were new facts that took place between the Supreme Court decision and the prior appeal, and that motivated and justified filing a second amended complaint. And then the third simplification is on the merits. The court doesn't need to resolve the dispute over whether copyright willfulness is required for a due process claim, since the complaint alleges willfulness and so survives regardless of which standard applies. Turning to the first issue, jurisdiction. The court lacks appellate jurisdiction over this procedural argument. Appellate jurisdiction is normally limited to final orders. There are a few exceptions, but those are narrow. The narrow exceptions include collateral orders, which the primary sovereign immunity appeal falls under, and pendant jurisdiction, for orders that are inextricably intertwined with another issue properly before the court. What I think my friend on the other side referred to as the same ball of wax. That's what pendant jurisdiction is for, issues that can't be separated. Defendant's procedural challenge doesn't fit into either of those categories. The ordered issue isn't final, and in fact, it's as far from final as you can get since it allowed the case to continue and allowed plaintiffs to file an amended complaint. It's not a collateral order, since it doesn't relate to an important issue or one that can't meaningfully be reviewed later. And this court considered that exact issue, whether it's a collateral order or whether pendant jurisdiction applies, in the previous appeal. So all that remains is a non-traditional route. Defendants advance a new theory for jurisdiction. They argue that the challenged order merged into the interlocutory collateral order on sovereign immunity. But the merger doctrine doesn't apply to collateral orders. Appellant's cases say the same. Their cases discuss the applicability of merger in connections with traditional final judgments. 68th Street, Jenkins, Gowan, they all say the same. And no case supports the proposition that interlocutory orders merge into collateral orders. And this makes sense. The merger doctrine is broad. Any decision on the road to a final judgment that plays into and feeds into the final judgment gets merged into the appeal, and so it doesn't need to be separately listed in the notice of appeal. If that same rule applied to interlocutory orders, then appeals that are currently confined to a single issue would balloon to encompass all of the orders in the case up until that time. This means that every appeal on a qualified or sovereign immunity issue would also include challenge to scheduling orders, discovery disputes, and intermediate case management decisions. And this case proves the point. Defendants are challenging an order granting plaintiff leave to file an amended complaint. That's exactly the kind of issue that shouldn't be the subject of an interlocutory appeal. Pendant jurisdiction proves the point.
Well, you know, I hear you, and your points are maybe directly related to what you're citing, but what we have here is a copyright suit that was filed against the state, and sovereign immunity was asserted, denying your claim against the state. And there was an argument that there was abrogation under the Act, Patent Act, Copyright Act, and we found the state immune from copyright. The Supreme Court affirmed almost for the same reasoning and sent it back. The only remaining party, the Friends, they settled, and that ended the case. So basically, the case was started as a copyright case, and it was ended with an assertion of sovereign immunity. Now you're basically coming in and challenging the ruling that you can't sue the state. And you say, oh, I've got a new theory. The new theory is under Georgia. There's something wrong with that. Number one is, first, you could have raised it earlier, but second, it flies in the face of the fact that both our court and the Supreme Court held the state immune from copyright. And you're now trying to find a theory to get around both courts. Now, maybe the courts didn't decide that issue directly, but they decided the issue. They said the state is immune. And so your whole process is really seeking a review of the August 17, 2020 judgment that ended the case because you now have figured out, well, maybe the Supreme Court really didn't decide Georgia, and maybe the Fourth Circuit didn't decide Georgia. Even though we had a Georgia claim, we're going to try that one. I mean, that's almost like claim splitting or second chance, or, you know, all the doctrines that we have to end endless litigation. And so when we take an appeal from this, and you're saying we don't have jurisdiction, at this point, we really ought to be looking at the bigger picture of protecting the judgment that was entered in 2020. It seems to me.
Right, so I want to address your concern on that. First I'll note with respect to jurisdiction, that doesn't fit under the merger doctrine. So the question for appellate jurisdiction is more academic, and does the court have jurisdiction? Merger doesn't provide it. Your concerns go more to the merits of the state's procedural argument.
I'm going to the fact that we have a final judgment, and that we told you that the state was immune from its copyright claims. Right. Now you're saying, oh, but we have a copyright claim, which you never asserted before, and you now do it under a case that was pre-existing. You had that case, and we cited the case, Georgia. It was around, and it may not even gain you. I think it's a very dicey analysis myself, but we don't need to get into that at this point because that's what you're alleging below, and the right way for us to handle that would be to let the district court resolve whether there's a Georgia claim and whether you assert the claim, and then we'd review that. But the question now is a procedural one: is can you reopen that judgment that went over all those years and through 3 levels of courts?
Right, and I want to be clear on this. Georgia, our claim has always been for copyright infringement, and we have always alleged a violation of the Due Process Clause. And Georgia has been in the case from the very beginning.
What do you mean has been in the case from the very beginning?
So what I mean is, in denying defendant sovereign immunity the first time around, the district court expressly acknowledged and cited Georgia, but did not need to reach that question of that.
But had you raised a Georgia claim in front of the district court?
So there's no such thing as a Georgia claim.
Had you argued that sovereign immunity had been abrogated under Georgia, sort of as applied abrogation rather than kind of prophylactic abrogation?
We didn't argue that in front of the district court.
Well,
However,
then, of course, the district court had no need to reach it. There was no claim in front of it.
Well, the reason the district court didn't need to reach it
is because you didn't raise it. District courts don't customarily need to address claims that haven't been raised.
Well, the district court specifically addressed Georgia in its decision.
Okay.
And it said, look, here we have prophylactic abrogation. And because we have prophylactic abrogation, I don't need to go any further. Georgia also allows for case-by-case abrogation, but here we've got prophylactic abrogation. In the words of the district court, it passed on that issue. And so then when the case went up, that decision, the only thing up on appeal in front of this court was a theory of abrogation under prophylactic abrogation.
Again, whatever the district court might have said, the only theory that would have been properly before this court would be the only theory that had ever been raised by the plaintiff. Whatever the district court did or didn't say, this claim was not raised.
I have two responses.
Okay.
The first response is, as an affirmative defense, you have sovereign immunity. So if you looked at what claims are raised, the claim that we had was one for copyright infringement that also alleged a due process violation. Or in other words, the facts that support a Georgia theory were present the entire time.
You're not supposed to be able to go theory by theory. Like, that's not the way the federal rules are supposed to work. That first you go with prophylactic abrogation, you run that up through the Fourth Circuit, all the way up to the Supreme Court, that proves unsuccessful, great, now I have a new theory. Like, that's just not how the rules are supposed to work.
And again, there are two reasons that that would support what has happened here.
Okay.
The first one is that since that first course of procedures happened, there were additional infringements that made the Georgia violation more clear. That's why the district court granted us permission to file an amended complaint to bring that out to the fore. And that's especially relevant because of the exchange that did happen at the Supreme Court, where defendants agreed that you could have a Georgia theory and agreed that the kind of conduct alleged here would support such a theory. And
I mean, they did agree that there is such a thing as a Georgia theory, but again, that's just because it's law, and it had been well-established law. Like, I don't know what else they could have said. I mean, you don't need a concession to establish the fact that there is doctrine out there. There is a Georgia case and a form of abrogation. No one can concede or not concede that.
yeah, so really quick, it's not just that the state conceded that Georgia exists. The state conceded that wherever you have willful infringement and there's not an adequate remedy, then you can.
Yeah,
then you
again,
can
well-established law. I mean, I really don't know. I don't think you need, whether they had said it or not, that would be true.
But the second reason, and I've referenced it a few times, the second response to your concern is to think of how things work in the normal course. In the normal course, you file a complaint, defendants file a motion to dismiss, and sometimes that motion to dismiss is granted and the complaint is dismissed without prejudice, as it was here. When that happens, because we favor review and disposition on the merits, plaintiffs routinely have the ability to come back and say, I've cured the problem in the complaint. There's a new theory or there's a new argument that can allow us to get around the claim of sovereign immunity or any other pleading defect that existed in the first place. The only thing that's different about this case is that the defendants were entitled and did take an interlocutory appeal, and that took time. It went back up, and then the end result of that process is the case went back down. And so it's no different than if the district court had dismissed the complaint in the first place, at which point plaintiffs under Rule 15 have liberal authority to amend the complaint, and the district court here, who has broad discretion to allow those kinds of amendments, decided that it was proper and allowed in view of the exchanges at the Supreme Court, the new facts and the new infringements that had come into play, and the normal jurisprudence like Foman versus Davis favoring resolution and disposition on the merits. And so under that rubric, deficiency in the complaint, identify a solution, fix the pleading error, there's nothing unusual happening here. There's no waiver problem, there's no forfeiture, there's just a plaintiff who sees a problem in his complaint and wants to get a resolution of the merits. And this plays out in the way that the district court approached the analysis in the motion for reconsideration. The district court, contrary to what we heard from my friend on the other side, the district court expressly considered Rule 60. This is on JA 65 to 66. Since the parties have argued the motion based on Rule 60B principles, and since Rule 60B is a more stringent standard than that of Rule 54B, the court considers these principles in its analysis. Regardless of whether the court addresses the issue of reconsideration on the standard of Rule 60B or Rule 54B, plaintiff's request for relief is granted. And the court then continues to apply Rule 60, the court then applies Rule 54, and then the court then applies Rule 15. Now, this court, and I can tell, has some misgivings about asserting a Georgia theory and whether that would be proper. But all three of those rules are reviewed for abuse of discretion. And the district court in this case found that it would be appropriate to allow the claims to be amended. In part, as I mentioned before, based on the new acts of infringement that gave new life and new motivation to those claims, that weren't there the first time around. And so that ought to put to rest the substantive concerns through the Rule 60, Rule 54, Rule 15 framework, even if the court is concerned about, you know, the general course, the bigger picture of how things have proceeded. I'd like to address briefly the timeline that we heard from the other side about what happened here, because we strongly disagree that there was any sort of finality. In defendants' telling of the timeline, they missed one key event. It's true, when the case was sent back down from the Supreme Court, the district court, pursuant to this court's mandate, dismissed the state defendants on some claims with prejudice and some claims without prejudice. At that point, there was one party left in the case. The defendant's argument is that one party was dismissed and the case was final. But there's an intervening event that happened before that stipulation of dismissal was filed. That intervening event was plaintiffs specifically sought leave from the court through a status report to file a motion for reconsideration.
And when was that?
That was on July 15th, 2020, which was shortly after the case came back down from the Supreme Court. So there were no, and the district court expressly found this in its decision.
Reconsideration of what?
Reconsideration of the district court's prior decision on takings and prior dismissal of the claim for copyright infringement. There were two bases for reconsideration that were offered. So we sought reconsideration, and then the district court made a decision to hold on to keep the case live. It was only after the court granted permission for us to pursue our motion for leave for reconsideration that we then dismissed Friends of Queen Anne's Revenge, the last party in the case. And so at that point, there was a live issue in the case. The case wasn't final. The district court did have more to do than enter judgment. The district court had to resolve, and it had decided that it wanted to resolve.
What was the court's response to your motion for reconsideration?
The court said you filed it under the wrong rule. It shouldn't be Rule 60 because there's no final
No,
judgment.
I'm talking about, this is before Friends was settled.
So before Friends was settled, we just had a status report. And so the court said,
Was there a formal motion for reconsideration?
the motion had not been filed. We had sought leave to file a motion.
All right, so there was no motion.
That's right, but there was a briefing schedule for the motion. And
Well, that
Well,
doesn't
which
resolve-
motion? Motion for,
our anticipated motion for reconsideration.
but you didn't file
We did file it, but not until after Friends of Queen Anne's Revenge had been dismissed.
Well, that ends the case.
Uh,
I mean, that's a pretty well-established principle.
I
There's
respect-
nothing left open when the last party is dismissed with prejudice.
I respectfully disagree, because there was something left open. The district court had made a decision to hold on to the case, and
Where's that decision?
that's the order granting our request for leave to file our motion for reconsideration.
Well, that's post-judgment.
It's,
There was nothing filed, there's nothing remaining after August 17 except a final judgment. And so you're coming in to remove that judgment, that's what your 60B is. It had to be a judgment. 60B requires a judgment to be filed. Didn't you see relief from judgment under 60B?
we sought relief from judgment under 60B. and
Okay,
that
so
was-
you acknowledged in your motion that you're seeking relief from the judgment.
and that was a mistake.
What did you want to file?
Because even at the time that we sought
No, what did you want to file?
a Rule 54 and a Rule 15 motion.
Rule 54 is a judgment, requires it too, it's to reopen a judgment.
No, Rule 60 is to reopen a judgment.
Well, Rule 50 is relief, modification of a judgment, isn't it?
Modification from a judgment, but not from a final judgment. So Rule 54.
Well, sure, it's a final judgment.
No,
It's not an appealable judgment. The time for appeal is deferred, but it's a final judgment.
It's not a final judgment because there were still Friends of Queen Anne's Revenge was
No,
still
sure,
after the case.
if you file it within 28 days, it defers the appellant. It's not final in the sense it's appealable.
Right. So and there's a relevant distinction between Rule 54 and Rule 60. There's not a dispute that at the time
I'm
we
just
sought-
getting back to the point that
Yeah.
I had thought you had filed, based on what you said, you had filed a motion for reconsideration before the Friends Party were dismissed.
No.
it was
We sought-
after that,
It was after that.
We sought leave to file it.
and they were dismissed with prejudice.
Right, so
And then you filed a motion for reconsideration under Rule 60B6.
that's correct. Under Rule 60B6, which the district court construed as a motion under Rule 54, but to be conservative, evaluated the motion expressly under Rule 60, then under Rule 54, then under Rule 15.
And that's when you got into the Georgia stuff.
And that is when we got into the Georgia stuff.
After that, you asked to try to make a claim under Georgia.
Right. But even turning to the
And
merits.
so if we're going to stick with that structure, we have a judgment, and you're seeking relief from the judgment because you have a claim under Georgia that you didn't pursue earlier, or that wasn't decided earlier?
If there's a final judgment, we seek relief from that final judgment on the grounds that there had been additional acts of infringement.
Well, now, that doesn't make sense. You know, the Supreme Court comes back and says the state is immune. The state now can use those films, whatever, because it's immune, aside from the fact that there were agreements that it could use it, which is another issue. But setting that aside, whether that's an infringement, theoretically, it's still immune from those.
Right, so I
I
want
mean,
to...
there's a judgment that says they're immune. So you keep saying there's new facts because they continue to use the film. But that's not new judgment. Those are already been declared to be immune.
Since my time has expired, I'll just say this briefly. It's important to parse out what the Supreme Court decided and what it didn't decide.
It decided immunity, right?
It decided immunity under a specific narrow theory under CIRCA. Not all theories under CIRCA. It did not make a grand pronouncement of immunity for all purposes, for all time, for all causes. The Supreme Court held defendants are immune from sovereign immunity under a prophylactic theory of abrogation under CIRCA.
What do you mean by prophylactic?
Under a theory of abrogation, so the Copyright Remedy Clarification Act purports on its face to say there's no sovereign immunity ever for any copyright infringement.
Right.
And what the Supreme Court held
It's unconstitutional.
is it's unconstitutional as a facial prophylactic measure. They refer to it as a prophylactic measure instead of facial in this field for some reason that's not clear. But Georgia allows for as-applied challenges. The Supreme Court did not reject that theory. The Supreme Court was actually quite receptive to it in the concerns that it expressed during the oral argument. And so there was not a pronouncement of the state is immune. There was a pronouncement of this theory that was decided by the Fourth Circuit and that was decided initially by the district court that didn't have to reach the other theory, right? That theory was invalid. But an alternate theory of prophylactic abrogation, which defendants admitted at the Supreme Court is valid, remains live.
Can I add just one quick question? Just the new acts of infringement, what about the new acts made them sort of better candidates for Georgia abrogation than the old acts?
They were a more clear evidence of intentional infringement. So Georgia, in order, and this is detailed in our briefs, I don't know that you want to have time to
I
get
don't,
everything.
yeah, sorry. You just think they were more obviously intentional, is your answer?
They were more flagrant, and they were more obviously
Okay.
intentional. Videos that the state had taken down shortly before its argument in this court last time went right back up.
Well,
Oh, this
yeah,
is
because
immune.
they were immune.
I mean, that's when we hold that they're immune, then that doesn't make it intentional or malicious in a sense. They were relying on our decision.
They were immune from copyright infringement.
Yeah.
That doesn't mean that the state then has free license to violate due process by infringing copyrights freely. Just because we can't sue them doesn't mean it's right to infringe, doesn't mean it's right to steal property.
Yeah. Well, it seems to me then, okay, I understand.
Thank you.
Yeah. All right, Mr. Brogue.
I have 3 brief points on rebuttal. Judge Harris, to your questions, I did not hear my friend on the other side identify a place where they had ever raised a Georgia theory in the prior proceedings in this case, and I think that makes sense because my friends conceded at the United States Supreme Court, and this is at page 32 of the oral argument transcript, that there was no Georgia claim in the case. Second, Judge Harris and Judge Niemeyer, to your questions, the civil rules do not allow parties to litigate one theory at a time, and I think that's what my friends on the other side are trying to do here. I'll flag the Omni Outdoor Advertising case from this court, which I think is somewhat similar in that a case went all the way up to the United States Supreme Court, and on remand, a party tried to introduce a new theory that they had never before raised in the case, and this court rejected that approach because, again, the civil rules don't allow litigation one theory at a time. The last point I'll just make briefly to my friend's suggestion that we had somehow conceded that a Georgia claim was viable in this case at the United States Supreme Court. we did not make any concession of that kind. We merely acknowledged the fact that Georgia is long-standing decisional law that had been on the books since 2006 and that the plaintiff here could have invoked when they originally brought this lawsuit back in 2015. Unless the court has questions for those reasons.
So your theory for jurisdiction in this appeal is collateral order doctrine,
Yes,
1291?
yes,
That's what you say in your brief.
yes.
So you say it's the final order.
The 2024 order is an
So you
appealable.
say that there's a final order jurisdiction here. 1291 is final order.
Your Honor, our position is that the 2024 order is a final decision under 1291 under the collateral order doctrine, and that as a result, the 2021 order, an earlier in time procedural ruling that gave rise to the 2024 order, is thus reviewable as well at the same time.
Is the theory that because it gave rise to it, it's inextricably linked?
I mean, I think that's maybe one way you could get at it. I mean, I sort of have thought of it more in terms of the merger doctrine. I mean, I think my friend is incorrect to say that the merger doctrine can't apply when you have an order like this. I mean, Rule 3C.
Are there any other cases where we've said the merger doctrine applies to two interlocutory orders?
I'm not aware of any. I mean, it is a
Normally.
little bit of a strange situation. The merger doctrine is a relatively new introduction to the appellate rules. Rule 3C4 itself does contemplate that the merger doctrine applies to a designated judgment or appealable order. And I think it is critical to my argument that we do have an appealable order.
You do have an appealable order.
Right,
But it's
right.
not a
And-
final order, and so I am.
Yeah.
Yeah, the collateral order
It's-
doctrine is an interlocutory appeal.
It-
So you're saying you've got an interlocutory appeal and it's a final order appeal also?
It's an unusual kind of appealable order because it conclusively determines that we don't have sovereign immunity, and that's why the United States Supreme Court in Puerto Rico Aqueduct held that we could take
Because the immunity
appeal.
is from trial
Exactly.
itself. And so they've allowed it to appeal, but how we categorize, it's collateral order, and that aspect is final, but it's not final from the whole case.
That's right.
Yeah.
That's right.
Okay.
Thank you.
All right, we'll come down and greet counsel, adjourn court for the day. Is that the last case?
Yes, for today.